is now in session.
Good afternoon. Before we start, let me just mention the council, we appreciate your participating in this process. We can continue to do this. Hopefully soon we'll be back to oral arguments in the courtroom. If we should have any problems related to the technology, just everybody take a deep breath and pause, and our crack experts will resolve it and get us all back going again. Mr. Hibner, call the case, please.
Ronald Martin Reese versus the Waters of Clinton, LLC.
We'll hear from the appellate.
May it please the court. My name is Deborah Reardon, and I'm here on behalf of the plaintiff, the appellant, Alicia Hancock, who is the power of attorney of Ronald Martin Reese. The question before the court today is whether the trial court erred in denying the plaintiff the ability to conduct discovery regarding the plaintiff's burden to establish substantial compliance regarding the requirements of Tennessee Code Annotated 29-26-121 and the alleged resulting prejudice to the waters. Ronald Reese is a Vietnam War veteran, and he was a resident of the waters at Clinton from August until September of 2017, where, due to the alleged negligence of the defendants, he developed infected wounds to his right hip and to his foot. Alicia Hancock, who is Mr. Reese's daughter and power of attorney, filed a complaint instituting this action on November the 27th, 2018, asserting claims for the injuries that her father had sustained. The Waters then filed a motion to dismiss, asserting that the medical authorizations that were included in the plaintiff's pre-notice packet were not HIPAA compliant as required by the Tennessee statute, because those authorizations did not include information identifying who the intended recipient of Mr. Reese's medical records was to be. While those authorizations admittedly did not strictly comply with the statutory requirements, strict compliance is not the standard, but substantial compliance is. And plaintiff maintains that she did substantially comply with the requirement here. Now, on July the 25th, 2019, the Anderson County Circuit Court entered an order that stayed ruling on the Waters motion to dismiss pending the Supreme Court's pending anticipated decision in Martin versus Rolling Hills, where the court had accepted review on the question of the role of and who bears the burden regarding prejudice or the lack of prejudice in the substantial compliance analysis. On April the 29th, 2020, the Supreme Court came down with the Martin versus Rolling Hills decision. And there the court explained that while prejudice is not a separate and independent element of substantial compliance, it is relevant to the substantial compliance analysis. And of particular significance is whether the plaintiff's non-compliance with the statute frustrates or interferes with the purposes of Section 121, or whether that non-compliance prevents the defendant from receiving the benefit of Section 121. The omission of a HIPAA element is not always prejudicial to the defendant. The Court of Appeals recognized as much in Hamilton versus Abercrombie Radiology Consultants. And there it held that it is not good practice to omit any of the CFR requirements from a HIPAA form, but that such omission is not always fatal to a plaintiff's case. Critical to this appeal is the fact that the Martin Court adopted the burden shifting approach from Myers versus Amasub regarding the question of substantial compliance and the demonstration of prejudice. Under this burden shifting approach, the plaintiff bears the initial burden of establishing compliance under Section 121 by stating so in the complaint and by attaching documents to the complaint showing that notice was provided. Then a defendant who wishes to challenge the plaintiff's compliance must file a Rule 12.02 motion to dismiss, explaining the plaintiff's failures. And if a defendant can demonstrate that one of the CFR elements is not contained within the medical authorization, then the defendant has made a prima facie showing of noncompliance. Once the defendant makes this prima facie showing of noncompliance, the burden shifts back to the plaintiff, and the plaintiff has to establish substantial compliance and that the noncompliance did not prejudice the defendant. The Martin Court explained the plaintiff may not rest upon the mere allegations or denials of its pleadings, but must respond by affidavits and other means provided by Tennessee Rule 56 and set forth specific facts demonstrating that the noncompliance did not prejudice the defendant. Martin concluded that the plaintiff there had not complied because the plaintiff rested on its allegations and arguments in their pleadings and did not submit any additional evidence in support of the lack of prejudice to the defendant. So in order to meet the plaintiff's burden of proof here, the plaintiff sought to participate in limited discovery related to the substantial compliance standard and whether or not any prejudice actually occurred in this case. The plaintiff submitted to the defendant 2 notices of deposition, one for the person who orders the medical records upon receipt of a notice packet, and the other for the deposition of the person who signs for and receives the notice packet. The plaintiff also submitted 4 interrogatories regarding any training of the employees in obtaining medical records and 5 requests for production. Again, those were limited and strictly sought to obtain policies that the Waters has regarding its obtaining medical records when it receives a notice packet. The defense counsel disagreed that discovery was appropriate or required and declined to participate in discovery. Therefore, the plaintiff filed a motion to compel and pursuant to Rule 3701 and attached to the motion to compel the plaintiff's limited discovery and asked the Anderson County Circuit Court for permission to develop a record in order to sustain its burden regarding substantial compliance.
Counsel, let me ask you, I mean, what could you find out in discovery that would show there was, no prejudice when the medical authorization form contained that blank information, blank spot for one of the core elements?
What the plaintiff anticipated that they were going to find in discovery was that the Waters, when it receives these notice packets, basically throws away the authorizations, doesn't do anything with them, would never attempt to obtain medical records, even if the authorization was correct. Of course, that discovery never occurred, so we couldn't prove that. But that was what we anticipated we would find. We wanted to find out what their policies were when they received these notice packets so that we could determine whether or not a deficient authorization would have made any difference at all.
In other words, you were hoping to find discovery that says when they got this authorization, they just tossed it?
That was something that we were, we anticipated that we would find. The circuit court, however, declined to permit us the opportunity to conduct any discovery on the issue, saying that that he was not converting the motion to dismiss into one for summary judgment and did not believe that the Martin court required that to happen. The court did have in front of it documents that were not just part of the pleadings, because in the plaintiff's response to the motion to dismiss, the plaintiff had attached some examples of authorizations that showing it was a common practice to leave recipients blank, that the defendants preferred to have the recipient blank, and had also attached to the motion to compel discovery the examples of the limited discovery the plaintiff had requested. Rule 26 provides that the parties can obtain discovery regarding any matter that's not privileged if it's relevant to the subject matter involved and if it relates to a claim or defense of the party seeking discovery or of any other party. This is a very broad right to discovery under the rules of Tennessee, under the Tennessee Rules of Civil Procedure. And the court here denied the plaintiff the opportunity to conduct even limited discovery when the plaintiff sought to do so under Rule 3701. Plaintiff submits that the circuit court's denial of that right to conduct discovery and to develop a record in order to sustain its burden of proof was error in this case.
What are we to do with, Hancock versus BJ BJR Enterprises, didn't it basically analyze the same medical authorization? Didn't this court look at that?
It did. Yes, Your Honor, it did. However, in that case, the trial court record that was developed was before the Martin case and before the recognition that the plaintiff had the burden of proving a lack of prejudice as opposed to a defendant proving that there was prejudice. And so in that case, the discovery was not sought because the Martin decision had not been handed down regarding that burden shifting analysis.
But I think counsel, well, your time's almost up, but let me ask you this. I mean, under your analysis, it basically, I mean, these issues related to compliance with the pre-notice, pre-suit notices are supposed to be decided on motions to dismiss. Our cases clearly provide that. And I think what you're arguing is that anytime someone requests discovery and wants to convert it to a summary judgment motion, they should be allowed to do that, which defeats the whole point of these being considered motions to dismiss.
Yes. Would you like for me to respond now, or do you want me to respond to my?
You go ahead.
I understand the court's concern about that, and motions to dismiss historically and by the letter of the rule, a court is to rule on the pleadings, and that's what a motion to dismiss is. However, in reading Martin, the Martin opinion, it says once a defendant files a motion that satisfies the foregoing prima facie showing, the plaintiff then bears the burden of establishing substantial compliance, and the plaintiff may not rest upon the mere allegations or denials of its pleadings. So I think that the Supreme Court has given us guidance that if the plaintiff can't just rely on its pleadings and must have other evidence, the plaintiff should not be denied the opportunity to find that evidence from the defendant.
All right, thank you. You have your time for rebuttal. We'll hear from the appellee.
Good afternoon, Your Honors. My name is Spencer Fair. I represent the appellee. This is a fairly simple issue in this appeal. Tennessee Code 2926-121A2E required the appellant to provide a HIPAA-compliant medical authorization permitting the provider receiving the notice to obtain complete medical records from each other provider being sent a notice. The medical authorization at issue in this case was sent to numerous potential healthcare liability defendants, two of which were the defendants in the trial court level in this case, the Waters of Clinton and Chadwick Hill. The other potential defendants sent this authorization were the defendants in Hancock versus BJR Enterprises, this court's docket number E2019-01158. And this court has already affirmed the Knox County Circuit Court's dismissal of that case on the exact same grounds. The appellant's Rule 11 application to the Tennessee Supreme Court in that case was denied. The medical
issue of requested discovery in that case?
Your Honor, there was no issue of requested discovery. However, the Martin case that the appellant is relying on here had come out before this court issued the Hancock versus BJR Enterprises decision, and this court even relied upon that decision and affirmed that trial court's dismissal. With respect to the plaintiff stating that we declined to participate in discovery, at the time they asked us to participate in discovery, this case was still stayed, and it required them to ask the court to lift the stay, and we declined because this is a Rule 12 motion. We did not submit any information outside of the pleadings in reliance on our Rule 12 motion. We did nothing to convert this to a Rule 56 motion, and the trial court did not convert this to a Rule 56 motion. In this case, the medical authorization at issue left blank the section for the name or other specific identification of the persons to whom the covered entity may make the disclosure, and that's core element 3 in 45 CFR 164.508C1. Not only did this substantive and significant failure make the medical authorization non-compliant with HIPAA on its face, but it further deprived the appellee of a benefit conferred by the statute, as it precluded them from being authorized to obtain the patient's medical records from all the other providers listed in the notice. Now, admittedly, the appellant here has approached this appeal differently from her unsuccessful approach in Hancock versus BJR, and claims primarily that the trial court erred in not compelling discovery to allow the appellant to build up a record on the issue of prejudice. We assert that this court should reach the same ultimate result it reached in Hancock versus BJR and should affirm that dismissal. The court in Hancock versus BJR determined that the identity of the individual authorized to receive the patient records is an essential element. This court also in Hancock versus BJR stated that when a pre-suit medical authorization is facially invalid, such as this one, the recipient is per se prejudiced and bears no burden to use or correct the form. I'm sorry.
Yeah, Captain, what do we do? I mean, the Supreme Court, did say in Martin that once the defendant establishes that prima facie case, that the authorization didn't contain one of the 6 essential elements. There's no question here this one doesn't. That the plaintiff may not rest upon the mere allegation denials of its pleadings, but must respond, and by affidavits and other means provided, set forth specific facts demonstrating that the non-compliance did not prejudice the defense.
Yes, Your Honor. It's our position.
What is the plaintiff supposed to do once that burden, Supreme Court says that burden shifts back to you, plaintiff? Now you got to do something else.
Your Honor, my read of the Martin decision, which this court may or may not agree with, is that
that's not really an option. Oh, if you're stating we have the option to not agree with Martin versus
with my read.
All right, go ahead.
That aspect of Martin was specific to the situation in Martin, which was a Rule 12 motion that had been converted to a Rule 56 motion because there was testimony submitted by a defendant that he had attempted to use the medical authorization and had been denied access to the records. So the court went through the Rule 56 analysis there because it was a Rule 56 motion based on testimony and determined that the plaintiffs in that case had the obligation pursuant to Rule 56 to respond by affidavit or in other means to demonstrate that the defendants were not prejudiced and failed to meet that burden. In a pure Rule 12 motion such as this, not relying on outside matters, we don't get to that point of the analysis because it's based on the pleadings. It's solely based on the pleadings. There's no right to discovery on a Rule 12 motion based on the pleadings, and the trial court was correct in denying the plaintiff's motion. I'll also state that the plaintiffs, the appellants, although they did not mention it in their initial presentation, I assume they will in rebuttal, they're also relying on a recent case, Woods versus Arthur out of the Western section. But in relying on that, they're also ignoring that the motion in Woods was also converted to a Rule 56 motion. The responding party submitted an affidavit of their attorney, and the court decided to turn it into a Rule 56 motion as a result. It's within the trial court's discretion whether or not to convert a motion to a Rule 56 motion. And in this case, they did not, because there was nothing outside the pleadings relied upon. And I do understand the quandary of how a plaintiff proves that, but this is a Rule 12 motion and we're stuck to the pleadings unless we submit something otherwise.
Well, but again, the Supreme Court in Martin says a defendant wishing to challenge the plaintiff's compliance with Section 121 must file a 12.026 motion to dismiss for failure to state a claim. And they go through and they say what the motion has to show, and one means of satisfying the burden is by alleging the authorization doesn't contain all the 6, and then they talk about. I don't see where they say anything about if it's somehow converted. They say the motion is supposed to be a motion to dismiss, and then they go through about who has the burden, when, and where.
Yes, sure.
What do they mean? Again? I guess when the burden shifts back to the plaintiff that last time, what is the plaintiff supposed to do, or what can they do? in a situation like this?
Well, Your Honor, I would say in the setting of a pure Rule 12 motion, they cannot conduct discovery because discovery is not relevant to a Rule 12 motion. I think I would say this suggestion by the appellants that there is some hybrid Rule 12, Rule 56 analysis as a result of Martin is misplaced. I think that's only applicable in a situation where it is a Rule 56 motion. Now, let's say you did ask a good question, Your Honor, earlier to the appellant about what did they expect to get out of this discovery they wanted to conduct. And what they stated was they were hoping to find out that the facility threw away the authorization. I hope they did. It was non-HIPAA compliant. We can't rely on that. And the courts have been clear over and over that we have no responsibility to test the medical authorization to see if it works. We have no responsibility to correct the medical authorization. We have no responsibility to let the plaintiffs know what you sent us isn't going to work for us. Please send us another one. That's what
they always throw away medical authorization they receive, whether it's compliant or not.
Well, that would be a different situation, I suppose, Your Honor. But in this particular case, what they would learn, if they did throw it away, good for them, I would say, because it's not compliant with HIPAA.
I understand. My question is, what if they always throw it away? Whether it complies, doesn't comply?
Then they make no effort to obtain records, and that's their right to do. They're not required to use a medical authorization.
You don't think that would show no prejudice to them? If they treated the same, they would have treated it the same way, whether it was compliant, HIPAA compliant, or not HIPAA compliant. You don't think that wouldn't show that they'd suffered no prejudice?
I don't think so, Your Honor. I think that perhaps that may be the best approach if they don't run it by counsel first to make sure it's HIPAA compliant before trying it. Anyway, Your Honor, that's my main point. This is a simple issue that this court has already decided. This court unanimously affirmed the trial court's decision in Hancock versus BJR that the same appellate in our case, using the exact same medical authorization, failed to substantially comply with the notice statute. Even with the appellant's attempt to shift the focus of her appeal, the result should be the same. And this court should affirm the trial court's granting of a Rule 12.026 motion and denial of the plaintiff's motion to compel discovery because nothing outside of the pleadings was relied upon, and the trial court was correct in all regards. And based on the plaintiff's failure to comply with the notice statute, they did not receive the 120-day extension, and the dismissal was proper, and the filing of the complaint was untimely. And if Your Honors have no further questions for me right now, I will turn it back over to the appellant's attorney.
Okay, I hear none. We'll hear from the appellant rebuttal.
Thank you, Your Honor. As Mr. Fair noted, in the Woods versus Arthur case, there was a question about the application of the summary judgment standard in reliance on the Martin decision. And I ran out of time in my first part to mention it, but I did want to point out that in that case, the plaintiff was actually arguing on appeal that the court should have applied the summary judgment standard and didn't. And then the court's analysis said that the trial court had considered additional documents and therefore it reached its decision under Martin the same way as if it using essentially a summary judgment standard, even though it did not specifically state that it had done so. Again, the Woods court referred back to Martin and relied on the fact that the plaintiff cannot rest on the allegations or the denials in its pleading, but has to respond with affidavits or other means provided by Rule 56. That is what the plaintiff has done here. And the plaintiff has been denied the opportunity to meet the burden that the Supreme Court has created for it. I've not been able to come up with any case law that says that a plaintiff should be denied the opportunity to conduct discovery when there's a motion to dismiss pending. And under Rule 26, a plaintiff is always given the opportunity to conduct broad discovery if it relates to a claim or a defense. And in this case, we've got a defense that has been raised by the defendant that the authorization is non-compliant, and the plaintiff should be able to meet its burden of proving that the non-compliance did not prejudice the defendant. And without the opportunity to investigate, even in a very limited sense, whether or not the alleged prejudice did in fact occur, then the plaintiff is prejudiced by the court's determination. Plaintiff submits that the circuit court's denial of the plaintiff's ability to sustain her burden of proof was error, and the plaintiff requests that the court remand the case for the purpose of allowing discovery limited to the issue of the plaintiff's substantial compliance and further proceedings consistent with that, and that recognizing the procedural differences in this case and the companion case of Hancock versus BJR, and that the record there was not established and therefore was consistent with Martin. And in this case, the plaintiff has requested the opportunity to create that record and was denied the opportunity.
Thanks to counsel for both sides. We appreciate your briefs and your oral arguments. Mr. Hivner, if you would please recess court until our next scheduled oral argument.
This honorable court is now in recess until 2:30 p.m.